Good afternoon. My name is Bandoma Callado. I am the president of the Filipino Bar Association of Northern California. Filipinx Americans make up a large portion of the nation's healthcare workforce. FBANC thanks you for your service and sacrifices that you make every day, especially during this pandemic. As COVID-19 continues to take toll on first responders and healthcare workers who remain on the front lines across the United States, planning for the possibility of serious illness or death is unfortunately necessary. This webinar will provide basic estate planning information. At the end of this webinar, there will be a time for our audience to ask our speakers some questions. So please make sure to type in your questions in the comments below, and we will do our best to address them. I would also like to note a couple of other resources for frontline workers. FBANC partnered up with Legal Access Alameda to provide wills assistance for emergency responders, including healthcare workers, first responders, grocery store workers, and food bank workers. For more information, please visit disasterlegalservicesca.org/wayfair. This Saturday, there is also an online conference hosted by PAWIS. It's called Justice for Workers Conference, where you can learn more about employment, immigration, and housing rights during COVID-19. To register, go to tinyurl.com/J4W20. I am going to go ahead and turn it over to our moderator, FBANC's Legal Clinic's co-director, Lynette Backling. Lynette is an attorney with the AIDS Legal Referral Panel. She represents people living with HIV who are at risk of losing their disability income or healthcare insurance benefits. Lynette has proudly served the Bay Area Filipinx community since first becoming involved with FBANC as a law student. Her involvement included volunteering at legal clinics and events, and emceed for FBANC's Gala in 2016. Additionally, Lynette is dedicated to providing pro bono services to marginalized communities. While in law school at Golden Gate University, she worked many hours pro bono helping survivors of domestic violence and low-wage workers. Oh, it looks like we just lost Lynette. Oh, there you are.
Hi, everyone. Hi, everyone. Sorry, we're having technical difficulties here. All right, so thank you, Mari. Thanks for the wonderful introduction. Good afternoon, everyone. So the Philippines has experienced so many frontline workers, healthcare workers, be they nurses, home caregivers, doctors, or pharmacy technicians to California and beyond. The reasons for this are detailed in the book written by our first speaker, Ceniza Choy.
Thank you.
Professor Choy is a professor of ethics studies and an associate dean of undergraduate studies at the University of California, Berkeley. She is the author of the books Empire of Care, Nursing and Migration in Filipino American History, and Global Families, A History of Asian International Adoption in America. Catherine received her PhD in history from UCLA and her BA in history from Pomona College. She is the daughter of Filipino immigrants. Catherine was born and raised in New York City. She now lives in Berkeley with her husband and their 2 children. Thank you, Professor Choy, for speaking with us this afternoon. We're going to talk about why approximately 1 in 5 nurses in California are Filipino or Filipino American. Can you please share with us a brief history of Filipino nurses in the United States?
Thank you for that introduction, Lynette, and thank you for being here. I'm grateful to the Filipino Bar Association of Northern California for organizing this webinar. This is a challenging time in the state of California, the United States, and the world given the COVID-19 pandemic. It is especially challenging for the Filipino American community because so many Filipino Americans are working on the front lines in the healthcare industry. In a recent news story by ProPublica, they reported that 1 in 4 of Filipino Americans in the New York, New Jersey area were health workers. Filipino Americans are physicians, they're pharmacists, they're phlebotomists. The most visible group of Filipino health workers is nurses. Since the 1960s, over 150,000 Filipino nurses have migrated to work and settle here in the United States. They've settled in states across the US, but as Lynette pointed out, in the state of California, almost 20% of the registered nurse staff is Filipino. This is not a new phenomenon. Filipino nurse migration and their labor in the United States is part of a long history that actually begins in the early 20th century. And if the host could please show my first slide. So this is the cover of my book, Empire of Care, Nursing and Migration in Filipino American History. It was published in 2003 by Duke University Press and co-published in the Philippines by Ateneo de Manila University Press. And on the left of this book cover image is Maria Abastia Beltran. Right before her departure from the Philippines, going to the United States in 1929. So in Empire of Care, I explored how and why the quote-unquote developing country of the Philippines emerged in the late 20th century to become the world's leading exporter of professional nurses. The leading destination historically for Filipino nurse migrants in the 20th century has been the United States. And in order to understand why the Philippines distinguished itself in US history and world history this way, I argue that I found in my research that we really need to go back to when the Philippines was an official colony of the United States from 1898 to 1946. In the early 20th century, the US colonial regime established an Americanized training hospital system, and US colonial nursing training trained Filipino nurses in an Americanized nursing curriculum that followed the professional nursing trends here in the United States. They also trained Filipino nurses in the study of the English language. So this training inadvertently prepared them to work in the United States. And after World War II, when the United States started to experience critical nursing shortages, especially in inner city public hospitals, US hospital recruiters turned to the Philippines. So if you could please go to my next slide. This slide is from a Philippine Daily Inquirer.net news story that just came out today. And it's a devastating story, but it is focusing on the Kanlungan online memorial, which is set up to honor fallen Filipino frontliners. This was organized by a feminist organization, Affirm, and you can visit this memorial on www.kanlungan.net. The exact numbers of Filipino health worker deaths related to COVID-19 have still not yet been confirmed. But we know that among those who have passed have included dozens of Filipino nurses here in the US, but also in other parts of the world, such as the UK. And what I want to emphasize is that this phenomenon of Filipino nurses working on the front lines of crises and epidemics here in the United States is not new. Since the 1960s, Filipino nurses have immigrated to the US, and they've served on the front lines of various epidemics historically, from the AIDS epidemic in the 1980s to Ebola and SARS in the early 21st century. Historically, they have faced numerous challenges. These include not solely these epidemics, but also workplace discrimination and racial and gender scapegoating. Regarding the challenges they faced with epidemics, COVID-19 is not the first time that Filipino nurses in the US have raised criticism of lack of training and protection as they serve on the front lines of these epidemics. Filipino nurses have historically organized to confront these challenges, and I want to leave you with two specific ways they have organized. The first is through National Nurses United. National Nurses United, one of the co-presidents currently is a Filipino-American nurse, Zany Cortez. And if you want to learn more about Filipino-American nurse participation and leadership in National Nurses United, please see Marissa Arroyo's film, The Strength of Many, which is available to be streamed on Facebook through the National Nurses United Facebook page. Another organization I'd like you to know about is the Philippine Nurses Association of America. And you can go to their website, www.mypnaa.org, and you can see their Heal Our Nurses campaign. They have organized historically for decades to improve the working conditions of Filipino nurses in the United States, and by extension, all nurses. So I encourage you to educate yourselves and also to support their Heal Our Nurses campaign. I wish you good health during this difficult time. Thank you very much for listening.
Thank you, Professor Choy. Our next speakers will be providing information on basic estate planning. I am excited to introduce Lorna Garcia de Guzman, a founding partner at Garcia and Sahni LLP. Lorna is a native Bay Area resident, having received her Juris Doctorate degree from Golden Gate University School of Law in 2005, where she was admitted as a Dean Scholar. Prior to obtaining her law degree, Lorna graduated magna cum laude, receiving dual undergraduate degrees with triple concentrations in management, economics, and finance from Notre Dame de Namur University. She was accepted and graduated as a presidential scholar, placing her on the Dean's list for all 4 years. Throughout her legal career, Lorna represented countless clients in a wide range of litigation claims while managing a significant caseload. Prior to founding Garcia and Sahni, Lorna was a senior litigation attorney for a well-known defense litigation firm, representing self-insured employers, third-party administrators, and corporations in all aspects of workers' compensation. She has an intimate understanding of the legal industry and has developed a strong professional network throughout her career of litigation. Lorna also previously served as in-house counsel, lead senior trial attorney for a Fortune 100 company. Thank you, Lorna. I'll now hand over the screen to you to talk about the basics of the financial power of attorneys and medical power of attorneys or advanced healthcare directives.
Thank you, Lynette. First off, I wanted to say thank you to everyone who's on the feed tonight. I want to thank you for your continued dedication and your heroic day-to-day contributions in caring for our community. Now, almost overnight, our lives have been turned upside down. Although it may seem like our circumstances are spinning out of control, we are not powerless. We're here today to help you learn how to take steps to protect yourselves and your families. Aside from the physical precautions you can take against the COVID-19 virus, in order to ensure the welfare of your family, we are coming together with FBANC, with Disaster Legal Services, to provide statutory wills, powers of attorneys, and advanced healthcare directives for our essential workers. I frequently emphasize to my clients the importance of providing instructions and naming the people who will oversee your medical and financial care during an incapacitating event. In fact, before this pandemic even hit our country, the odds in the United States of becoming disabled before the age of 65 are 1 in 3. Now think about that, everyone, 1 in 3. That is a very scary statistic. And even with this statistic, many individuals fail to recognize the likelihood that they may become incapacitated during their lifetimes. Now, this may be because becoming disabled feels less common and less inevitable than death. However, as healthcare workers, you know it is highly unusual for an individual to go from being healthy to dead with no intervening decline. Now, when someone passes away, there's a death certificate, no question that this deceased individual can no longer handle his or her affairs. But when you're still alive, your attorney or your agent is going to have to prove to the court that your financial and medical decisions making should be overridden. Now, that is a more challenging case to present. Without the correct paperwork in place, obtaining the right to speak on your behalf while you're still alive is difficult. And this is especially true if the court has no instructions from the disabled party. Now, with that in mind, let's take a look at the documents that you'll be creating in order to convey your needs and wishes. In your durable financial power of attorney, you can see what the form looks like on the screen. You'll be designating an agent to make financial and property decisions for you when you're unable to handle your own affairs. Now, because of the prevalence of stay-at-home orders, travel restrictions, and self-quarantines, please make sure that the person you designate is available to act as your agent. Consider designating an individual you trust who is ethical, diligent, detail-oriented, and good with money. It may also be wise to choose an agent who lives close by to efficiently act in this role. Now, for those of you that are married, one would typically list their spouse as their agents. For any agents you wish to designate, you'll need their name and address. Although you can list multiple agents to hold this power of attorney, I usually don't recommend this, as the more agents you have, the greater the potential for a conflict to arise. Now, please note, this power of attorney is effective immediately upon notarization of the document, unless you specify otherwise. In the future, should you decide to revoke this power of attorney, this can easily be done by writing your intentions on paper along with your name, date, and signature. If you wanted to revoke this power of attorney, I would recommend notarizing that as well. Okay. Now, the cornerstone document for medical planning is the healthcare medical power of attorney. Okay. And you'll see when you go onto the Disaster Legal Services website, it's titled Advanced Healthcare Directive. And so the next 3 documents that I'm talking about are gonna all be encompassed within this file. Within this document, you'll be naming the person who will communicate your medical wishes to your doctors in the event you are too ill to speak for yourself. Now remember, the person you put in charge is perhaps more important than the content of the document itself. Good people can save a bad plan by the choices that they make for you. However, incompetent people who make bad choices can mess up a perfectly good plan. And I say this for a few reasons. A typical medical power of attorney, like the one on the screen, is more focused on granting powers to your agent than it is on providing specific instructions. This document includes generic statements about the standard of care for pain management. While general guidance is better than nothing at all, your medical agent is going to need to make specific decisions when he or she is called into action. There are just too many medical scenarios to provide specific instructions for each situation. So what does that mean? This means that your medical agent will likely have to make decisions regarding situations that no one could have anticipated, with only minimal guidance. Now, because medical decisions are personal in nature and more often than not are based on emotional or spiritual values, it would be best to designate an agent whose beliefs are aligned with your own. In addition, while most of us would like to believe that our family members are not going to fight over our medical care, Unfortunately, it is common for families to disagree over the right course of medical action for their loved ones. So this being said, you want to make sure that your agent not only understands your views on medical care and end-of-life scenarios, but also has the backbone to stand up to your family members and maybe even your doctors who may disagree. It would also be wise to name an alternate agent in the event your initial agent is unable to act in this capacity. For your medical agents, you should provide your agent's name, address, and contact phone number. This document can either be witnessed or notarized. Now, included in this document is also the Advanced Medical Healthcare Directive. This document covers two possible events. Number one, if you suffer from a terminal condition, and number two, if you're in a persistent vegetative state. The purpose of completing this document is to give you the option of prolonging your life or not during either of these events. This document is not meant to prevent death, but rather to remove the burden of this choice from your family members. Because both the Advanced Medical Healthcare Directive and the Medical Power of Attorney reference each other, it is important to ensure that your wishes in both of these documents are consistent in their messages. Now, lastly, you'll be completing the HIPAA release. These authorizations will ensure that your designated family members are able to obtain and discuss medical information with your providers. Please keep in mind these documents are statutory forms intended as a stopgap for you in the event you were to become incapacitated in the near future. They will not avoid the probate process. So the majority of you on this feed today, once the situation has settled down, I would strongly recommend you speak to an attorney to reestablish your estate plans to avoid the probate process. Thank you again to all of you, and please stay safe and healthy.
Thank you, Lorna. That was really great. Our next speaker is Jeff Tachiki, a senior counsel at Perkins Coie. He guides clients through the complex issues that arise in estate planning and during trust administration and probate, including disputed matters. Jeff has particular knowledge of California's non-conforming trust and estate law, specifically the elements relevant to trust and estate administration, and is a certified specialist with the State Bar of California in estate planning, trust, and probate law. Jeff is a frequent speaker on a variety of trust and estate planning topics. Jeff is also very active in the Bay Area legal community. He serves as chair of the Estate Planning and Administration Committee for the East Bay Trust and Estates Lawyers, and is a member of the Judicial Appointment Evaluation Committee for the Alameda County Bar Association. Jeff has been recognized by the Alameda County Bar Association barristers with the Distinguished Service Award and Super Lawyers as a Northern California Rising Star. Thank you for joining us, Jeff. I am now handing the screen on to you.
Thank you so much, Lynette. And thank you to all of you healthcare workers. I echo both Professor Ceniza Choy's thoughts as well as Lorna's, and really wanting to express my appreciation for all of the work that you guys do on the front lines, putting your lives at risk to take care of us in the community. We can't thank you enough for all of that. And Lorna did a great job covering the issues that present themselves when it comes to your potential incapacity. My role in all of this is to go over the statutory will that is also available to you on the waiver page, and take you through some of the issues that come up there. I don't want to belabor some of the details that are on there. I think going through the video is probably the best way to get a lot of that information, but I wanted to point out some of the highlights and some of the things that you really should consider when putting this will together. And I want to emphasize up front that this will is intended to be a stopgap measure. Lorna alluded to this during her discussion, that these documents are really not comprehensive kinds of documents, and really putting something together for most people that you would want to do that utilizing an attorney and doing something that is a little more custom to your specific circumstances. And these documents are more of the square peg in the round hole, but they serve as a way to get basic wishes down during these sort of extraordinary circumstances. And so they are, for lack of a better term, better than nothing. But it's important that you understand that this is not something that you should rely on long term. And I think you'll see as we go through the will a little bit that just how rigid it is, and that it probably does not fully reflect the wishes that you might want to carry out as a will. And we hope, to be honest with you, that this will not ever be used for a very long time. So with that being said, jumping into the will itself, I think the first thing I would like to point out about this is that there are if you were to look at the first couple of pages of this document, there are a variety of instructions, questions, and answers in there that are actually very useful. They were not put together by me, or they were actually put together by the State Bar of California, and they actually answer a lot of questions that you may have as you put this will together. And so I encourage you to go through that, and perhaps if you have a question as you're filling out this form, you may actually find the answers in there. And then below that, there are also, as you can see, a set of instructions that you should also follow that are also very important. We'll talk about witnessing these documents at the end, and who should be served as witnesses and those kinds of things. The other thing that I want to point out before we go through some of these things is that it is really important that you understand what a will covers and what it actually does not cover. There are a lot of things that you may own that on your death may not actually be covered by your will. For instance, if you own property that is, let's say, your house in a form of what's called joint tenancy, and maybe it's joint tenancy by itself or joint tenancy with right of survivorship, right? The surviving party, the person who co-owns that house with you, is actually entitled to that house if you were to pass away. And because of that, your will actually does not control that house on your passing. So as you're filling out this will and you're contemplating who you want to leave your house to, it's probably going to be important that you look at the title on your house. And if you don't have a copy of the deed that shows the title on that house, you can go down to your local county recorder's office and pick up a copy there. And you want to see how it is you own title. If you are married, it is more than likely that you own it with your spouse, and more than likely that you either own it as joint tenants with right of survivorship, or possibly as community property with right of survivorship. But in either case, if it says right of survivorship or it says joint tenants by itself, then whoever co-owns it with you will inherit that house on your passing, and it will not be subject to your will. By the same token, you may have bank accounts that are also joint tenancy accounts. You may also have what are called pay on death designations on your accounts, or transfer on death if you happen to have an investment account. In any of those cases, if you've designated a beneficiary, or if you have a joint tenant on your account, again, whoever that beneficiary designation is, or whoever that co-owner is on that account, will inherit that account on your passing. And again, it will not be subject to your will. Speaking of joint tenancy accounts, I also want to point out that a lot of times, a lot of us put what are called payors on accounts as well. And those payors are not joint tenants. And sometimes it's hard to differentiate between the two, but a payor is just simply someone who has the ability to sign checks or deal with that account on your behalf. And if you've structured an account that way, and you've named someone as a payor, it does not mean that they will inherit that account on your death. It just means that they have the ability to write checks. And when you pass away, that account will still then be subject to your will, right? Other assets that you might want to think about in terms of whether or not it's going to be subject to your will retirement assets, so your 401ks, your 403bs, any IRAs that you might have, life insurances as well. Those all have the ability for you to designate beneficiaries on each of those items. And so as you're putting this will together, you may want to check with your benefits coordinators, with your IRA plan custodians, and check with them to see that you have beneficiaries designated on each of those accounts and on your life insurances, all right? And it's really important that you do that, because if you don't, then there's a chance that those accounts will not end up with the people that you want them to end up with. So make sure as you're going through this process that you're looking at those things as well, all right? Now, turning to the will itself. In this will, you will actually be designating beneficiaries to receive everything else. So anything that I haven't covered before, if it's just a checking account that is in your name, if it is a house, if you are single and you own this a piece of real property in your own name, all those kinds of assets will all be subject to this will. Your personal property, your tangible personal property, the things that are in your household, those are also subject to your will. And so you will be designating beneficiaries of those kinds of assets. You will, if you have children, minor children, you will be able to designate guardians for them if you happen to pass away, which I know is really, obviously, really important for all of us with children. And then you will obviously be designating executors, someone to carry out all of the tasks that have to come about when you happen to pass away. And like what Lorna had said about picking agents on your power of attorney, again, when you're picking an executor, you want to ensure that you're picking somebody who is responsible. They don't have to be rocket scientists. They don't have to be really good with money or anything. They just have to be responsible, generally speaking. And make sure that you designate more than one person. There are blank spaces in there to designate to designate 3 people on there, and so make sure that you are doing that as you fill out the form. Now, the other consideration as you go through this form, and again, if you refer to the videos, they will go through the videos take you through each of these forms step by step. But I want to point out something, and it is mentioned in these videos, but I want to point something out about the rigidity of this document. There are very few options for leaving your property to somebody, your assets. So, and that means, again, whether that's your house, whether that's your cars, whether that's your bank accounts, there are very few options for doing that. So, and it's designed that way specifically because the courts want to make sure that this document is easy to read and it leaves no room for interpretation about what you have done, all right? But that also means that you have very limited options about what you can do with this will. So one thing that I want to point out about this is if you're going through this document and you see something where you say, look, I don't really want to do what this document is telling me are my options. I want to leave my property to someone else other than what my options are here. You should understand that you should not cross out anything on this form, all right? Also, do not add any language to this form. So for instance, if you look at one of the sections in there, which I think is 5B, it is a section in there that allows you to leave your property, leave your residual, the remainder of the balance of your estate, to a bunch of people. But if you notice there in choice 4, it actually says you have to leave everything equally among there are 4 lines there. So you have 4 people you can designate to leave your property to. And but you have to leave it to them equally. So if I get a lot of questions that say, well, Jeff, what if I want to leave 20% to Joe and 30% to Jane and 50% to Mary? I can't actually do that in this will. I have to leave everything to them in equal shares. So, but again, you're limited to that. There's no way around those kinds of provisions. And so that's why, again, it leads me back to this point that you should view this as a stopgap measure, because again, there's a high probability that this is not going to be, it's not going to really reflect what you actually want to see happen with your estate. All right. And then beyond that, once you finish all this, so once you fill out the form, you want to make sure that you are obviously signing this, and that you are signing this document in front of witnesses. All right. Now, who should witness these documents? The form itself says that the witnesses that witness your signature should not receive assets under the wills. Now, I'm going to amend that comment and tell you that anybody who is actually named in that will should not be a witness to this will. So if it is a guardian, if it is an executor, if it is a beneficiary, you should not have any of those people sign this will. So who can be that? Who could fill that role? A good person is like your neighbor or your coworker, because more than likely, most of us are not leaving any of our estate or naming those people in our will at all whatsoever. Those are good people to fill this role as witnesses. All right. Now, when you go to actually sign it, make sure that you are signing it in front of them. Don't sign it ahead of time and then take it to them and say, hey, this is my signature. Can you witness it? In order for them to witness your signature, they must actually see you sign it. So make sure that you're signing it in front of them, and then make sure that they're reading those statements where it says under penalty of perjury that they're declaring that they have seen you sign this will, that you've declared it to be your final will, all of those things. And then obviously make sure that they sign their names below that, all right? The other issue that comes up a lot, or the question that comes up a lot for me, is where should I store this will now that I've executed it? The best place to store this, quite frankly, is in your house. A lot of people will say, well, maybe I have a safe deposit box. Is that a good idea? I'm actually not a fan of the safe deposit box. There is a statute on the books that actually allows somebody to get access to a safe deposit box if you were to pass away, for the sole purpose of retrieving a will. But as a practical matter, in my experience, when someone goes to the bank and requests that access when someone has passed away, typically banks are resistant to that, and you end up fighting, an uphill battle to try to get access, despite the fact that the statute actually exists. So my personal opinion is that as a practical matter, it's better to keep this document in your house and let your executors know where this document will be. And you don't have to, if you want to keep it in a fireproof box, that's fine, but make sure that you also have, if it's a combination, that this executor knows what the combination is, or that they know where the key is to the box, right? Otherwise, keep it with all the rest of your important documents in your house, and just make sure that that person knows where it is. In terms of naming executors, I typically recommend, obviously, if you're married, you're probably going to be naming your spouse. But I think, like I said before, you should name someone who is going to be responsible generally, and typically family members make good bets here. So those are some of the considerations that you should probably think about as you're filling this out, and understand that when you're looking at all of your assets and who you're going to be leaving your assets to, that those beneficiary designations, the joint tenancy kind of designations that you have on certain assets, those are all separate from what you're designating in your will. And you have to sort of think about all of those things as a whole in order to make sure that you are leaving your assets completely in the way that you actually want to do that. So with that being said, make sure you do refer to the videos. They are quite helpful in ensuring that you fill out these forms in the correct way. And with that, again, thank you for your service and on the front lines and taking care of all of us again. Appreciate it. Back to you, Lynette.
Thank you. Thanks, Jeff. Great presentation. Okay, so as Mari mentioned earlier, FBANC has partnered with Legal Access of Alameda to provide wills assistance for emergency responders that include healthcare workers, first responders, grocery store workers, and food bank workers. At this clinic, volunteer attorneys will help complete wills, power of attorneys, and advanced healthcare directives forms over the phone for free. There will be assistance in Tagalog from volunteer attorneys. And if you like more information, please visit disasterlegalservicesca.org/Wayfair, WAFER. Right. All right. Thanks, everyone. Let's now move on and answer some questions from the audience. Okay. Give the audience some time to ask some questions. Okay, we have a good question here. This could be either for Lorna or for Jeff from Giorgio. Due to shelter in place, can witnesses sign documents via e-sign methods?
I have not done the e-sign method, but I believe in California, notarized documents cannot be signed electronically, and notaries are essential workers at this time. And so all of the estate plans that I have done during the shelter in place are not e-sign. I don't know if Jeff.
That's my experience as well. You can utilize, my understanding is that especially for things that need to be notarized, you can actually use an online notary as long as that notary is licensed to engage in online notarizations in their jurisdiction. So there are a variety of states in the country that actually allow online notarization. And so if you can find a notary, and if you can do searches for those online, if you can find a notary who is licensed in, say, Texas, for instance, which I know is a state that allows those notaries can actually notarize things online. Now, as a practical matter, I don't know how readily accepted they are in California, so I would probably advise against it generally. But if you don't have no other option, you simply can't leave your house or what have you, that could be an option of last resort, I think. Yeah. But actually signing the documents, you should, other than the notarized document, if you're talking about your will, or you were getting the healthcare directive, for instance, witnessed, you should probably sign those things in pen.
And a follow-up question to that, if it was a matter of last resort and we had to use like an e-service to get it witnessed, do you think it would be more prone to be challenged later on? And do you think that would be a problem?
Yeah, I mean, that's probably why. I don't know, to be honest with you. But my sense is that even if it were, it may not be. I would be less worried about it in court as I would be just as a practical matter for, say, banks, for instance. I think that's where you're, again, as a practical matter, you're more likely to run into that being an issue. But the real answer is I don't know.
Yeah, and I echo Jeff. I'm not sure either. I've been sticking to the wet signatures and the in-person notaries.
Sounds like better be safe than sorry kind of thing. Okay, so next question. This one is for Lorna in regards to medical power of attorneys, advanced healthcare directives. You mentioned that you can appoint agents, and also with the financial power of attorneys as well, you can appoint agents. Is there a specific number of agents you can appoint? Can there be more than one, or is it like you do maybe one agent, and if that agent becomes unavailable, then you can appoint another one?
I believe on the statutory forms, there are two spaces for two alternates. Now, you typically, if people are going to appoint multiple agents at the same time or jointly, it's usually about two. I wouldn't even recommend the two, but if they wanted to do 2 or 3, you could do that. And then they can decide whether they want these agents to act separately, so they can act in and of their own capacity, or they can act jointly. Now, in the event that they request that your agent act jointly, that can be a problem if they disagree on something. Now, in these statutory forms, I don't believe that there's any type of resolution if an issue were to arise. And so in that case, they would have to likely go to a probate court to resolve that dispute.
I would agree with that. Yep. And in fact, the form has a blank space on there that actually says if you designate co-agents, you need to say, I want them to act jointly or I want them to act separately. And you're supposed to write that into the form itself. So, yeah.
Thank you. Okay, so we have another question for Jeff. This one, this question is about your will needing to be very specific, and you're talking about that. Make sure there's no room for interpretation. If there is some room for interpretation, and if there is like some conflict there, what's the remedy?
Well, I don't know exactly what the remedy is, but it's one of the things that would be in front of the probate court when the will is what we call probated, right? So when someone passes away, that will get submitted to the probate court for to be administered, right? And it's the judge's job to interpret the will, and then all the parties who are interested in that will file their own or positions as to what they think the will actually says. And again, the hope with the statutory will is that there is very little room for interpretation. So, and by filling it out appropriately, the hope is that there shouldn't be any sort of those problems. But to the extent that there are, that's what the probate court is there for, to try and resolve those issues. Yeah.
Thank you. And then we have another question for Jeff. With like all these natural disasters that are going on and with the wildfires the last few years, what happens if you have like a will in a safety box, but it's destroyed or lost? What would be your recommendation there?
That's a good question. So I would also probably recommend that you make a copy of a will. It is never going to be as good as having the original will. The probate court really feels strongly about seeing a wet signature on the will. That's to ensure that they know that this will wasn't destroyed, wasn't revoked, right? Because you can actually revoke the will by actually destroying it, throwing it in, burning it up, tearing it up. All of those things are considered revocation of your will. So if the will is lost, there is a presumption that this will has been revoked. And there are ways to overcome that presumption, and you can do that by submitting a copy of this will, but then you've got to present other factors to prove that this will is in fact the decedent's last will. All right. So as a stopgap, as a sort of backstop, if you made a copy of the will and you kept that copy somewhere else, that's better than nothing if you want to ensure that that will ended up in the probate court. But ideally, you would keep that original will as safe as possible. Or if your house burned down, for instance, you would prepare another will at that time.
All right, do we have any more questions from the audience? We'll give it maybe just a few more seconds.
There's that one question about whether the beneficiaries are taxed, which I can.
Oh, yeah.
I can respond to
I
really
didn't catch
quickly.
that one. Yes.
So the answer, generally, there are various kinds of taxation out there, but the general answer is no. They're not. If you were to receive $100,000 from somebody else, you are not taxed as income on that amount, right? But that being said, there are forms of what we call estate taxation out there, but it's only for very large estates currently that are in excess of $11.58 million. But anything below that is not subject to this estate tax. There is also potential for some income tax, but that is only as to the amounts or that is interest and dividends and things like that, or rent, perhaps income that has been accrued or received after the passing of the decedent. So generally speaking, the answer is no, and there could be some property tax reassessments and things like that if we're talking about real property, but there's no actual tax on the amounts actually received per se.
Okay, we have one more question. Have you found there are cultural challenges to Filipinos or other communities creating or executing powers of attorneys, advanced healthcare directives, statutory wills? How have you addressed them?
I can answer, or I'll start and then you can chime in, Jeff.
Sure.
I know that I have been very challenged with trying to teach my parents' generation, so the baby boomers, that a lot of them are first generation into this country, more educating them on the will, power of attorney, trust process. Now, a lot of them that came here to live the American dream, work hard, buy the nice stuff so that our kids don't have to work as hard. But they weren't taught how to preserve these assets and how to make sure that they pass along to their family without going through the probate court process. And so for me, it's a matter of educating that generation as well as their children, because my parents didn't grow up knowing this. And so how was I going to know, right? And so I think that was one of my biggest challenges.
Yeah, I mean, I would agree with that. And I think, for a lot of families who are recent immigrants to the country, the countries that they came from have very different systems for dealing with these things post-death. And the US system is quite complicated. And, unless you had some reason to really investigate it or learn about it, it's really common to be ignorant about it, and that's not necessarily anybody's fault. That's just the way that happens to work out. And but unfortunately, it means that a lot of people who are recent immigrants to the country don't know that they need to do anything about these issues, and don't know how difficult the process really is if you don't have planning in place. And so that's I mean, I think I echo Lorna's thoughts in that I think it's getting those families, those persons who are recent immigrants to the country, that it's really important that they do these things, because the system isn't set up to really take care of them in the way that they think it is.
If there are no more questions, again, thank you to our frontline workers for your service, especially during this pandemic. We hope that you found this presentation helpful. Thank you again to Professor Choy, to Lorna and Jeff for speaking with us this afternoon and helping us with understanding the basics of estate planning. Again, we encourage all of you to go to disasterlegalservicesca.org/waiver for more information and or assistance from volunteer attorneys. I'm going to go ahead and share that link again below, if I can find it. All right, it doesn't look like we have any more questions. Thank you again, everyone.